So I think I'm going to start now. Heartfelt welcome from me to this session on international law and international tribunals. Why are there not more climate cases before international intergovernmental tribunals, and what can we do about it? This is an online seminar, part of a series that we are organizing for the 6th time now. Last year, 3 panels, and this is the 3rd of this year's panel, together with the Böll Foundation, who is also hosting this Zoom conference, with German Watch, with Green Legal Impact, and with an association of critical law students. It's a series directed at young lawyers, law students, young practitioners, but also aiming at a wider audience of those who've got more experience and also lay people. We will try to use a language that is understandable for everyone, but nevertheless there might be cases in which, well, I or my panelists here will have to go into a little bit more detail and become a little bit more legal in tone, and so please bear with us. It will go away, and we'll return to some more normal language afterwards. There is a couple of technical details which I would like to share with you. First of all, this session is being recorded, and everyone who has registered will receive a link to share afterwards. We'll also put the link in the chat soon, probably at the end. There's 2 ways to communicate with us. One is through the chat, and the other one is through the question and answer function, which you will find at the bottom of your screen. Please, for all questions to me, to our panelists, please use the question and answer function, because otherwise it will become incomprehensible for those working on the backstage. And also in the question and answer function, you have got the option to actually vote for certain questions, which will then go up in the hierarchy and have a better chance of being posed. On the other hand, I instructed our colleague Lea, who's operating the question and answer tool, to also check those which haven't received that attention, so that you don't need to be worried that a question might submerge under a wave of questions. So please use the chat, the question and answer function for all questions that you have, and not the chat. We will inform you and provide information with links. They are being posted into the chat. That's the main channel through which we will communicate with you, aside from our video function here. So I'm very happy to welcome you here and welcome my friends and colleagues to a panel which is promising to be extremely interesting. I'm joined today by Sophie Marjanak. She is a colleague of mine from Client Earth, working with the climate program, and a senior lawyer and climate accountability lead at Client Earth. Welcome, Sophie. She'll be the first to present some results and activities with regard to the Torres Strait Islands case. Second, I would like to welcome Professor Lavanya Rajamani from Oxford University. I know her from the COPs, from the Conference of the Parties, the climate regime, the United Nations Framework Convention on Climate Change, Kyoto Protocol, and the Paris Agreement. And she has written a very well-known book on international climate law, and will inform us about some of her research that she's done into the international legal sphere and litigation. And thirdly, Philippe Sands. He is a Queen's Counsel with Matrix Chambers. He's also Professor of Laws at the University College London, and is an expert on international litigation at the International Court of Justice, the Tribunal on the Law of the Sea, the International Criminal Court. And he has also been co-chair of a commission that recently looked into the issue of ecocide and came up with a definition of it. That's our panel today. And we would like to start with Sophie. Please, would you take the floor? Thank you.
Thank you so much, Herman, for the introduction, and it's fantastic to be here today with you all and to see such a great turnout. My name is Sophie Marjanac. I am the Climate Accountability Lead at Client Earth. I'm an Australian qualified environmental lawyer, and I am going to discuss today, give you with a presentation about one of the most exciting climate cases in which Client Earth is involved, and one in which we are absolutely privileged and thankful to be able to support a group of Torres Strait Islanders and their communities who are bringing a climate claim, human rights claim against the Australian government in the UN Human Rights Committee. I will start this presentation. I'll take around 20 minutes and try to keep an eye on the chat for questions, but of course really happy to take any questions at the end. So if we can go to the next slide, please, Jeremy, that would be fantastic. I'll introduce Client Earth, I'll work through the legal issues in the claim, and then at the end of this presentation, I will touch on global trends in human rights and climate change litigation, the role of science in this case and the importance of science in climate change litigation globally, and then also the role of campaigning and local community engagement in climate change litigation and ensuring that outcomes of litigation are effective politically. So next slide, please, Jeremy. So who are we at Client Earth and what do we do? Basically, we are an environmental legal charity, as I hope that you all know. We work around the world. We have over 200 staff working on issues related to climate, nature, chemicals, and forests. I work in the climate program, and our focus is on climate change law and litigation. And this case falls within our work stream on human rights. Obviously, over the past few years, there has really been an explosion of climate change cases around the world. I think that's as a result of ordinary citizens and lawyers also realizing that the courts are a powerful tool that we have in the fight against climate change, and that courts, where states, governments, and other regulators are failing to tackle the issues, courts have often the power and the ability to step in and drive state action as well as changes in corporate behaviour. So there's been a huge increase in climate change litigation over the past decade, but especially in the last 5 years. We're calling this the second wave of climate change litigation globally. It's quite distinct from that occurred in the mid-2000s because we're seeing more success in these cases than we ever have. And there's also, particularly in the last 5 years, a human rights turn in that climate change litigation. And we're seeing more and more cases brought before human rights specialist regional courts and tribunals, as well as national courts, that use human rights as the basis of their claims, and those that are brought by climate vulnerable people who are affected by climate change significantly. So the trend towards using human rights as a tool to tackle climate change, I think, is just actually beginning, and we'll continue to see more of these cases in the coming years. So if we can go to the next slide, please, Jeremy. So our clients, I have the privilege, as I said, to represent 8 clients who live on 4 very small, low-lying tropical islands in the Torres Strait of Australia. So the Torres Strait is part of Australia, but as you can see on the map, it is very close to Papua New Guinea. It's a narrow strip of sea between the tip of Cape York and Papua New Guinea. Torres Strait Islanders are Indigenous Australians. Their ancestors have lived in the region for thousands of years, and they are recognised as one of Australia's first peoples, and they have special status in much Australian law and policy because of that. If we can go to the next slide. So here are the Torres Strait 8. These claimants live on 4 low-lying islands that, as I mentioned, are between 3 and 10 metres above sea level. One of the islands is a swampland, and the others are coral cays. So they are really very small, less than 5 kilometres long and around 2 kilometres wide. Torres Strait Islanders have experienced a history of colonialism, dispossession. They have experienced the stolen generation. So often the Australian state took children away from families. And there is also a history of stolen wages. So the state often forced Torres Strait Islanders to become indentured labourers in the cane fields of northern Queensland. And so there's a long history of dispossession and of real challenges for these communities. And now they are facing the devastating impacts of climate change on their island homes. And obviously, as Indigenous people, their connection to their land and to their country is absolutely crucial for their life, because they live from the island. It's crucial to their sense of identity as Indigenous people, and it's crucial to the maintenance and continuation of their culture. I would now like to play for you. I'll start screen sharing my own screen and just play for you a short video that I think gives you a really good sense of the issues from the BBC. So I'll just share my screen. Okay.
There is no tone, Sophie. Sophie, we can't hear anything.
Can you help me? I need this iPad plugged in somehow. Like it's about to die and I'm on a webinar. Can you help.
Sophie, something's going wrong here. Sophie?
Yeah.
When the water rushed through, all remained
please, I think this doesn't work, Sophie. Can you please stop that and continue?
So you had no sound then?
Nope.
Okay. All right, I will. Okay. I'll move on to the next slide, and you can all watch that video separately. Anyway, you can see from these photos the significant climate vulnerability of the islands. And in that video, Yassine Mosby, one of our clients, was talking about the impacts that he's living with day to day. So he was showing there the remains of his ancestors, which have been exposed by rising tides. You can see there the flooding and inundation that the islands experience annually at the highest tides. And you can see him talking, you can hear him talking about the serious and significant impact that relocation from the island would have on his family, not only existing generations, but most importantly and most concerningly to our clients is future generations. So how that culture and how that sense of all the traditional ecological knowledge about living on the island, about how to live on the island, how to practice culture on that land will be unable to be passed on to future generations if the communities need to be located or relocated. And so this is the factual basis of the claim. If we could go to the next slide, thanks. So here you can see another image of the inundation experienced. This is from Boigu Island, and you can see a comment from the communities there that scientists don't need to tell them about climate change. You can come here and see it. If we move to the next quote, I think this again, just to the next slide. Thank you. So this is a quote from Kebe Tamu, another one of the claimants. And he says that their culture has a value to us that no money could ever compensate for. It starts with the land. It's how they're connected to the land and sea. You wash away the land and it's like a piece of us you're taking away from us. And so that really quite visceral connection between the Indigenous culture and the physical island is the basis of our claim. And now I'll move to the next slide and I'll work through some of the legal arguments. So Australia is a global laggard on climate action. And I think that the world is beginning to wake up to this ahead of COP. It ranks very low in the Climate Change Performance Index. It has the highest per capita emissions in the OECD. It has an inadequate target, emissions reduction target of 26% by 2030. It has no net zero target or long-term strategy, which are requirements under the Paris Agreement. It has insufficient policies to meet its existing target. It did not change its NDC, that's its nationally determined contribution under the Paris Agreement, ahead of COP26. And it continues to export and subsidise coal, oil and gas significantly. It's in fact the world's largest exporter of LNG. So I can move to the next slide. So our clients have made a claim under the optional protocol to the International Covenant on Civil and Political Rights, alleging that Australia's climate policy violates, firstly, their right to life, that's protected by Article 6, their right to arbitrary interference with their privacy, families and homes under Article 17, and importantly, and for the first time, they allege a violation of Article 27, which is the right of Indigenous minorities to continue to enjoy their culture, practice their own religion, and use their own language in community with other members of their group. And there's an interesting intergenerational element to that third claim under the right to culture that I will touch on. We can move to the next slide, thanks. So the remedies that our clients are seeking in this case are twofold. So firstly, they relate to adaptation. And this is the really practical solutions that are required to protect the islands from rising sea levels. In respect of adaptation, the authors request that Australia take all steps necessary to ensure the continued habitation of their islands, and that there be fully comprehensive study of coastal infrastructure and defences required in respect of each island to allow their continued habitation. To date, there has been some construction of seawalls in the region. However, the funding has been insufficient to provide the necessary defences from the sea on each island. And it's very much been applied by local government in the region in a triage sense. That is, that the money has had to be spent on the absolute worst high-risk areas where homes were most at risk. It's simply not a long-term solution for this really complex challenge that the communities are facing. So the first ask is in relation to adaptation. If I can move to the next slide. The next ask relates to mitigation, and that is reduction in greenhouse gas emissions, which is, of course, the root cause of the problem. And here, our clients make an argument based on setting a human rights standard that is in line with the Paris Agreement. And essentially, they argue that Australia must increase its nationally determined contribution, so increase its emissions reduction target to at least 60% by 2030 and commit to net zero by 2050, and put in place measures to meet those targets, and then also to cease support for thermal coal and to phase out coal mining as soon as possible. So those are the remedies sought in respect of mitigation. We can move to the next slide. Thank you. So the communication was filed in May 2019. Later that year, the government did commit an additional 20 million Australian dollars to emergency seawall works in the region. However, our clients and their communities have been clear that this is insufficient to deal with the problem. As I said, these emergency works are required to really stop homes from crumbling into the sea. They're not sufficient to meet the scale of the problem. The state replied in May 2020, and then our clients replied again late last year in September. Australia committed not to use Kyoto credits in 2021, and then we have had another response from the state a few months ago in early August. We now wait for the committee to make a decision on the case and issue its views, and we hope that that will come in the next 6 months or so, although it's difficult to say. The committee does have a backlog of cases, so we are now waiting for the final decision. If we can move to the next slide. Thank you. So one of the key legal issues in this claim is victim status, and this is a prerequisite. This is a precondition for a finding of a violation of a human rights obligation by a state. So individuals need to be found to be victims. The state in this case is arguing that the threats to our clients and to their communities are insufficiently direct for them to claim to be victims. They also claim that the clients, the risk to the clients is to be manifested in the future and not in the present. That is, that the islands, because the islands have not yet become uninhabitable, that essentially the future risk of harm is not sufficiently imminent, and that there is time until the islands are totally uninhabitable for the state to intervene to prevent the rights violation. And we say that this is an incorrect interpretation of the test. There was a very helpful case that was decided by the committee. If you can go to the next slide, Jeremy, which we say, and we think it will be very helpful for our clients. And this was the case of a man from Kiribati who had been living in New Zealand without a correct immigration status. New Zealand sought to extradite him back to Kiribati, and he argued that if that were to be done, then he would his right to life would be violated due to climate impacts in Kiribati and the fact that rising sea levels, increasing heat, inability for communities on Kiribati to grow food in their gardens because of increasing salinity in the soil. He argued that therefore he couldn't experience proper sufficient conditions to enjoy the right to life with dignity in Kiribati. He did not succeed in this claim. However, the committee made the really, I think, significant comment that the risk, and I've highlighted it, I've underlined it here on the slide, that given that the risk of an entire country becoming submerged underwater is such an extreme risk, conditions of life in such a country may become incompatible with the right to life with dignity before the risk is realised. And so this is an incredibly helpful, we say, argument for our clients who are really, on in a very similar situation. If we're talking about relocating those communities, planning for that really needs to start now. They're already experiencing, as I mentioned, they're seeing graves being washed out, cultural sites are being lost because of the link between their culture and the land on which they live, and also the need for them to live as cultural people, as Indigenous people. Our argument is that the right to life with dignity will be violated in the years before the islands become absolutely uninhabitable. And that's the basis of each of our arguments. If we can move to the next slide. Another key legal issue that the state has challenged is state responsibility for greenhouse gas emissions. The state has argued that no country can ever be responsible for the impacts of global climate change because it is a global problem to which all states contribute, and that therefore within the international law on state responsibility and attribution of international acts to states, they say that it is not possible to attribute to any one state the impacts of global climate change. And we say that this simply cannot be correct, because this would leave a lacuna of protection for victims of climate change all around the world. And it would mean that international law really had nothing to say on this issue. And we've argued that the issue is not whether any one state can be held responsible for the majority of all global greenhouse gas emissions, which of course we know is scientifically impossible because it's a problem to which all states contribute, but really that each state is responsible for its share. And that is adopting the decision of the Supreme Court in Agenda that each state must take responsibility to reduce its own emissions created within and on its territory in line with the Paris Agreement, and that the rules of state responsibility apply in this circumstance of greenhouse gases. So we hope that we will succeed on this point as well before the committee. If we can just go to the next slide, Julian. I just note that there are a few really helpful statements, many helpful statements coming out of international organs and national courts on these issues at the moment, on which we hope to rely. So obviously the Human Rights Committee General Comment number 36 on Article 6, the right to life, made a very, we say, sensible and logical point that in interpreting human rights law, relevant standards and norms of international environmental law can be used to set the standard. And it's this comment, this part of the general comment on which we rely to argue that the Paris Agreement is relevant in interpreting states' obligations under human rights instruments. There was another really helpful statement from several other human rights treaty bodies in September 2019. That statement again picks up this point that I've just said, that international environmental law is relevant to the interpretation of international human rights law. The OHCHR has put out a really helpful fact sheet on human rights and climate change. And I'll just focus on two really fantastic cases, both in Europe. So obviously Agenda Foundation and the State of the Netherlands, if we can flick to the next slide. There's the relevant paragraph from General Comment 36. Can move to the next slide, Jeremy, that'd be great. And there's the joint statement. We just move to the next slide again. Thank you. And here is the most relevant paragraph from the groundbreaking agenda decision, where the court said that the assertion that a country's own share in global greenhouse emissions is very small and therefore makes no difference cannot be accepted as a defence. And the court points out very logically, we say that acceptance of these defences would mean that a country could evade partial responsibility by pointing out other countries or its own small share. And if this defence is ruled out, each country can be effectively called to account for its share of emissions, and the chance of all countries actually making their contribution will be greatest. So this is a fantastic precedent that we have directed the Human Rights Committee to in the Torres Strait claim. We can go to the next slide. Thanks, Jeremy. We'll try to speed up. Again, another decision recently, April this year, of the German Federal Constitutional Court, where the exact arguments that we are making before the Human Rights Committee have been picked up by the German court, and in this case, the courts found that the Paris Agreement sets a relevant threshold. They've called that the constitutionally relevant temperature threshold, within which the state's actions are to be interpreted. And again, that's bringing the Paris Agreement into domestic human rights law, which is a fantastic precedent, and we hope the direction that this area of jurisprudence will go. We can go to the next slide. So the role of science. I just wanted to briefly mention, in the Torres Strait Islanders case, we provided the committee with evidence in relation to impacts on the islands. So the physical impacts and the predicted impacts, that was signed off by one of the top IPCC scientists on sea level rise. And that was really important. I think that will be really important to ground our case. And we also provided expert evidence on Australia's emissions reduction policies. But obviously, without strong science, there is no basis and no grounding on which to take these claims. I think happily in the Torres Strait case, the state has accepted the science of climate change, but its arguments have, and it has not challenged any of the evidence put before it from the claimants, which I think is telling. They are really focusing on the legal arguments, and that's where the views of the committee will be so crucial. If we can go to the next and final slide, I'll just briefly touch on the political campaign and the work that our partners, which is 350.org Australia, are doing with the Torres Strait and their communities. So this is not just about the law, it's about building a movement within these very small communities and giving them the opportunity to tell the world about the situation that they're facing, to tell the world about what a very small place, very remote place, doesn't normally get a lot of attention. And so we've partnered with 350.org, who are working with the grassroots communities to help tell their story to the world in a culturally appropriate way. So they have been involved, all of the communities have been involved and consulted at every stage through the process, and traditional law and traditional decision-making processes have been followed. We've also partnered with GBK, which is the Torres Strait Sea and Land Council, and we've sought consent and buy-in from the other local governance bodies and systems of traditional decision-making. And that's been an absolute priority for us. The campaign has focused a lot on art and music and telling stories through those mediums. I really do encourage you to find them on Instagram and find them on their website. They've got some beautiful new videos up so you can actually see what a special place the Torres Strait is and why protecting it, not only for its natural biodiversity, its natural characteristics, but also for the cultural characteristics and the cultural heritage that we are at risk of losing because of climate change. And I think that is one element that perhaps if we're focused on risks to the environment, we can forget that we are also at risk of losing Indigenous cultures, Pacific cultures, and this is a loss not only for Torres Strait Islanders, but in fact for all of us. And I will end there.
Thank you, Sophie. Our plan was to start this session with a very important and concrete case. And you have really fulfilled this in showing us what Client Earth is doing in order to bring international law to the fore and to defend the right of the islanders. Everyone who is watching this scene is wondering why aren't there more cases? And so I would like to call on Lavanya Rajamani to switch on her video. And Lavanya, you are a professor of international environmental law. You are watching the scene, you are doing research on international climate law and international climate litigation. And we'd be really, really interested to hear what can be the explanation for this lack of cases at the intergovernmental level, and do you have some suggestions for remedying these?
Thank you, Herman, and thank you also to Sophie for a really fabulous presentation and also for the work that that Client Earth is doing in this context. I'm actually going to answer your question, but I'm going to do it in a slightly circuitous sort of manner and focus on some other judicial forums, which I think will soon be approached for sort of dealing with the issue of climate change. And that's the forum that all of us are sort of beginning to think about, the International Court of Justice. So the International Court of Justice is yet to be presented with an opportunity to pronounce on climate change, but it will likely be soon. There have been abortive efforts by the Republic of Marshall Islands and Palau in the past to approach the General Assembly to seek an advisory opinion from the ICJ. But the government of Vanuatu, as I'm sure many of you are aware, has just this last week announced the launch of an initiative to seek an advisory opinion from the ICJ. So to answer your question, Herman, while it's certainly true that of all the sort of fora that have been approached, the international fora have been perhaps the last to be approached, I think there's some very promising sort of prospects in this context. So what I would like to do now in the sort of 10 minutes or so that's been allocated to me is to speak to what the International Court of Justice and international fora more broadly can usefully say in the context of climate change, can usefully pronounce on in the context of climate change. To do this, we have to step back to actually ask what gaps and ambiguities there are in the international climate change regime, which the International Court of Justice or any other international fora to varying degrees and in varying ways could helpfully plug and clarify. So there are at least 3 gaps that I see in the international climate change regime, and these gaps are ones that prevent us, or sort of at least are slowing us down in reaching the global temperature goal or to climate stability. Now, these gaps relate to ambition, accountability, and fairness. Now, I think international courts, and in particular the International Court of Justice, could usefully plug these gaps and clarify the content of the legal obligations that states have in relation to addressing climate change and its impacts. So let me speak briefly to each of these gaps. The first of these gaps is the ambition gap. Now, the centerpiece of the Paris Agreement, which of course was a product of tremendous and incredibly contentious negotiations, the centerpiece of this agreement is a binding procedural obligation placed on states to submit nationally determined contributions. And there are three things to note about these nationally determined contributions. First of all, that these contributions are nationally determined, not multilaterally negotiated. So states actually have a great deal of autonomy in setting these targets for themselves. And they've exercised that autonomy, as we saw in the context of Australia in Sophie's presentation. Some states have chosen not to adopt very ambitious targets and contributions for themselves. So these targets are nationally determined. There is no mechanism to review the adequacy of these targets, adequacy of these national contributions in relation either to ambition or fairness. So we have no multilaterally agreed mechanism in the climate change regime or in the Paris Agreement to review the adequacy of these contributions. And moreover, there is no obligation of result attached to these contributions that states undertake. So states have autonomy in choosing these contributions. There is no mechanism to review the adequacy of these contributions, and these contributions are not subject to obligations of result or achievement. So what this has resulted in, not surprisingly, is contributions that do not add up to what is necessary to achieve the purpose of the Paris Agreement, which is to hold temperature increase to well below 2 degrees centigrade, to strive for a 1.5 degree temperature limit. So the first round of NDCs in 2015 put us on track to a 3-degree temperature increase, at which level there would be sort of severe, pervasive, and irreversible impacts affecting not just the Torres Strait Islanders, but many other parts of the world. Current NDCs, which is including the second round of NDCs, about 86 new or updated NDCs have been provided by 113 parties. That includes the EU. And including the second round of NDCs, temperature increase is above 2 degrees centigrade. It's estimated to be above 2 degrees centigrade. In terms of emission reductions, if all of these contributions are implemented, emissions are expected to be about 16% above 2010 levels in 2030. And according to the IPCC special report on 1.5 degrees, we actually need to be 45% below 2010 by 2030 and reaching net zero by 2050 for us to reach 1.5 degrees. So we're a long way away from being on a trajectory to reach 1.5 degrees. So if you add all these nationally determined contributions, there's a very significant ambition gap. If you take all the net zero targets and announcements into account, and many have been made in the recent past and will continue to be made around COP26, many of these net zero targets are not yet reflected within the regime in long-term sort of low development, low emissions strategies that states are requested to provide under Article 419 of the Paris Agreement. Which leads me to the second gap, the accountability gap. So there is an ambition gap, very clear ambition gap. There's also an accountability gap. There is no mechanism to generate accountability, individual accountability for targets taken by states. So although states are required to provide information with their nationally determined contributions, they can actually choose the information requirements that apply to them. There is an enhanced transparency framework, which requires states to provide information necessary to track progress in achieving their nationally determined contributions. But the transparency framework was very carefully negotiated to exclude a robust review function. So the accountability for the targets taken and their achievement has thus far been mostly demanded outside the process by non-state actors and outside the formal UN climate change regime, which partly explains, to speak to some of Herman's sort of questions, partly explains why there's such an increase in climate litigation, at least the national and regional levels, because the climate regime is not able to provide that accountability function. There's an ambition gap, there's an accountability gap. There is also a third and very important fairness and equity gap. So central question in the negotiations right from the start, and I know Philippe, who's going to speak on this discussion, in this panel discussion as well, was involved right from the beginning of the negotiations. Central question has been how to fairly share the burden of addressing climate change, given historical responsibility of some states, the fact that small island states in least developing countries have very limited contributions, yet are going to be at the forefront and front line of the impacts, and even larger developing countries that have contributed to greenhouse gas emissions have enduring poverty and energy poverty challenges, countries like India. So there are some very fundamental equity and fairness issues at the heart of this issue. Yet we're all in this together. So how do we actually determine whether each country is doing its fair share? So the cases that Sophie referred to, Urhenda and Neubauer case, the German Federal Constitutional Court case, raised this issue of fair shares. It's also an issue that is being raised in several sort of cases that are before the European Court of Human Rights, in particular the Portuguese children's case. So the Paris Agreement sidestepped the issue of differentiation and at least the issue of national sort of multilaterally agreed sort of burden sharing, but it is cropping up in climate litigation because at the end of the day, countries need to feel a sense of fairness if they have to feel a sense of ownership for the solutions that are being asked of and the sort of contributions that are being asked of states. So there are very few avenues for equity and fairness within the regime. So there's a serious gap within the regime in terms of fair shares, but is being raised in national and regional cases. But in each of these cases, whether it's Urhenda or the German Federal Constitutional Court case or the Portuguese children's case, when a court is approached and asked, whether that state's contribution is fair, the court will automatically ask, how do we determine whether it's fair? What is a benchmark that we use to determine whether a state's contribution is fair or not? So you do need to agree on some sort of criteria for what a state's fair share might be. So in the context of these three gaps in the international climate change regime, that is the ambition gap, the accountability gap, and the fairness gap, what can an international tribunal or the International Court of Justice actually do? First, the International Court of Justice, if it's sort of approached for an advisory opinion in this, could interpret the provisions of the Paris Agreement, in particular Article 4.2, which deals with the nationally determined contributions, and Article 4.3, which places an expectation of progression and highest possible ambition on states. It can interpret these provisions in the light of the customary international law principle of harm prevention and the duty of due diligence that attaches to it. So while states do not have an obligation of result attached to their nationally determined contributions, they do have obligations of conduct in relation to the domestic mitigation measures they're required to take to implement their nationally determined contributions. And the duty of due diligence attaches to this obligation of conduct, which means they have an obligation to deploy adequate means, to exercise best possible efforts, and to do the utmost to obtain this result. This is from the Seabed Disputes Advisory Opinion. So although due diligence is an inherently variable standard, it is not infinitely malleable. And if the International Court of Justice fleshes out the standard of due diligence in the context of what we expect from states in relation to climate change, it would discipline the discretion and autonomy that states have in choosing and implementing their nationally determined contributions. And this is crucial. States cannot continue to have the kind of discretion and autonomy they have in relation to their nationally determined contributions if we are to reach the global temperature goal. How do we discipline this national discretion and autonomy? One way to do that is to interpret and clarify the standard of due diligence that attaches to the obligations of conduct that states have in this context. The second, I think, key intervention the International Court of Justice could make here is to identify and elaborate on other customary international law principles, such as good faith and cooperation, and apply them in the climate change context. Many of the Paris Agreement's core provisions place a good faith expectation on states rather than relying on binding obligations of result. And the reason for this, of course, is sort of political dysfunction at the heart of the climate negotiations, which didn't permit the acceptance among states of binding obligations of result and a multilaterally agreed sort of arrangement in relation to what each state would do. That was beyond the realm of practical politics. So what we do have in the Paris Agreement are many good faith expectations placed on states. But what does good faith require in this context? What does cooperation require in this context? The ICJ could usefully flesh this out, again, limiting the autonomy and discretion that states have appropriated to themselves in the shift towards national determination. So, for instance, such a determination of what a good faith expectation could be, what cooperation could mean in this context, may help us assess, for instance, if Brazil's updated new first nationally determined contribution is actually a downgrading of its commitment, and whether it's a breach of good faith, of a good faith expectation placed on states in relation to their contributions. But that's just one example. It could be other examples of nationally determined contributions that might actually be a breach of good faith and a breach of the cooperation duty placed on states. Third, the ICJ could identify, determine the legal status of and operational relevance of principles of international environmental law, such as the principle of common but differentiated responsibility and respective capabilities in light of different national circumstances, inter- and intra-generational equity and special circumstances, which could then guide states in determining what their fair share is. Again, an issue that's been cropping up, as I said before, in national and regional litigation on climate change and human rights, but it's an issue that the ICJ could usefully pronounce on in the context of interpreting principles of international environmental law. Ultimately, what an international fora, and the International Court of Justice in particular, could do is interpret the relatively open textured treaty obligations in the Paris Agreement in the light of well-established customary international principles such as harm prevention, good faith, and cooperation, as well as the principles of international environmental law, to bring much needed clarity on the nature and extent of legal obligations that states have in relation to addressing climate change. So this is a set of I guess, directives, in a sense, that the International Court of Justice could pronounce on, set of issues that the International Court of Justice could pronounce on, which would usefully contribute to our ultimate sort of understanding of what states can be expected to do and should do to meet the global temperature goal. So I'm going to leave it there, but of course I'm happy to take questions, including sort of extension of the questions that you asked, Herman, on the nature of litigation and the dearth of litigation at the international level. Thank you.
Thanks, Lavanya. That's fascinating. And I'm moving on to Philippe. Philippe, you are an academic and a practicing lawyer. You represent states at the global level, at the intergovernmental level, before courts and tribunals, and have some experience with both with environmental law and with international criminal law, not least because you've been co-chairing the commission to define the ecocide, the crime of ecocide, in an attempt to insert them into the statute of the International Criminal Court. Having listened to what our colleagues have just said, what's your take on this? What are the substantive opportunities and the procedural options that we have with regard to international environmental and climate law? And as we've just heard, I mean, it's not only environmental issues, it's human rights issues which are closely linked to it. And by the way, there's also the issue of deterritorialization. Whole states may disappear, territories may disappear. What does international law have to say in this instance. It's a peaceful destruction of states, so to speak, or destruction of a state in peacetime by peaceful means. Do you see any chance of bringing this before international courts and tribunals? The floor is yours.
Thank you, Herman, and all the colleagues who've organized this, and thanks also, obviously, to Sophie and Lavanya for two very fine and very thoughtful, I thought, contributions about what is being done in the context of the human rights domain, and also Lavanya's no surprise, incredibly thoughtful person, on what an international court, or what the international court could do. I'm spending a lot of time thinking about what international courts could or could not do. But I think my function right now is to put in a reality check about the prospects and the risks, as well as the opportunities. And I'm doing that because precisely I spend quite a lot of time before international courts and tribunals, and I sit also as an international adjudicator on a particular category of disputes, investor-state arbitration, which increasingly, interestingly, is raising issues of global environmental concern, but seems not yet to have been a focus for efforts by civil society. And I do think civil society ought to be looking a lot more closely at investor-state arbitration in terms of getting bang for your buck. We know that the European Court of Human Rights right now is considering cases in relation to the European Convention, and I think there's reason to suspect the court is taking that incredibly seriously, and so that may also be very interesting. But let me follow on from Lavanya and focus on the ICJ and the International Tribunal for the Law of the Sea, and share a little bit in relation to my own experience. And I think my own experience is very deeply formed by the advisory opinion proceedings that I have been involved in. And I'm not actually involved only for states, but also for civil society and NGOs, and sometimes for the corporate sector. So I think I've got a reasonably broad perspective. And indeed, as you mentioned, I'm obviously very open to exploring how this could be done. I would like to find a way for it to be done, but I want it to be done properly, because I'm extremely concerned that if it's not done properly, it will actually cause very significant damage. And let me say why that is. Back in the mid-1990s, well, in fact, starting in the 1980s, NGOs wanted to get an advisory opinion to the International Court of Justice to on the legality of the use of nuclear weapons. And it followed a very similar approach to what is happening now. It took many years to get one, and eventually the World Health Organization and then the United Nations sent, respectively, two requests. The WHO request was excluded on jurisdictional grounds. The court said the WHO didn't have a mandate to deal with issues on the legality of the use of nuclear weapons, but it accepted jurisdiction on the General Assembly request, and it proceeded to give an advisory opinion. The advisory opinion was significant and positive in certain respects. It led, for example, at paragraph 29, to the first time the court has ever expressed views on environmental obligations under international law. It said the obligation to protect the environment has now entered the corpus of international law. And that was extremely positive, and it opened the door to much litigation that followed. Gabčíkova and Maroš, the pulp mills case, the Australia-New Zealand case, which was extremely significant. And that Australia-Japan case on whaling is the case that turned me to imagining that it could be possible to send something on climate change to the International Court of Justice or to the International Tribunal for the Law of the Sea. But, and this is the very big but, the International Court of Justice in the end split very dramatically on the ICJ advisory opinion request from the General Assembly, 7 votes to 7. And the casting vote was by the President of the International Court, who effectively gets a second vote. And the effect of that advisory opinion was to say that there were circumstances in which nuclear weapons might be used consistently with international law. In other words, it clarified, it sought to fill a gap, rather as Lavanya has suggested, might happen in relation to climate change, but it did so, in my view, catastrophically. It would have been better in respect of that part of the advisory opinion for there to have been no advisory opinion. It has not moved the debate forward. If anything, it's made it much more difficult to argue against the legality of the use of nuclear weapons. And so that experience 25 years ago is strongly ingrained in my consciousness. And what I took away from that experience is that the composition of the court is the thing that you've got to look at very, very carefully. And I fear that many of those who, with the best of intentions, are looking at taking things to the ICJ or ITLOS are not asking themselves the question, who is on the court or ITLOS, and what are they likely to want to do or not do? These are essentially rather conservative bodies, and there is a generational change here. Unlike some national courts where there are increasingly younger people on board, most of these international courts that we're talking about have people who did their legal training before environment was part of the conversation, have not been steeped, as many people on this call are, in relation to climate change issues. And so there's a huge educating process to take place when you're at the International Court of Justice. Now, 25 years later, we faced this issue. What would you ask? And we faced this on the most recent advisory opinion. And the most recent advisory opinion was from the UN General Assembly, again, in relation to decolonization and whether the colonization of Mauritius or the decolonization of Mauritius had been completed. And this concerned, of course, Chagos and the British Indian Ocean Territory. And I don't have time to get into detail on that process. I don't think that's particularly helpful. But what I learned from the nuclear weapons advisory opinion was you've got to come up with questions that are absolutely precise in the sense of leaving the court no wiggle room in terms of which direction it might take. We spent 3 years, a little group of us, drafting the questions, bouncing them around and taking them to people who had formerly been associated with the court or who had argued a lot of cases on the court and arguing with them about the kinds of questions that could go. And so we ended up with 2 questions that then went to the General Assembly and then went to the International Court of Justice. And those questions were very precisely crafted and left the court very little room for maneuver. And that's why on this occasion, the court gave, given also the composition of the court, a very clear advisory opinion. Of course, the United Kingdom has stuck 2 fingers up at it, but the United Kingdom is pretty much alone in the world in having done that. And the court has authoritatively set down a clear conclusion. The United Kingdom's occupation of the Chagos archipelago is illegal and it must leave. And that went to the General Assembly and that was then adopted by a subsequent resolution. So the real challenge is, what are the questions you're going to send to the court? My own view, and Lavanya will know this, questions that go to principles. What are the principles of state responsibility that apply? What do you mean by good faith? What do you mean by due diligence? With the greatest of respect, are going to come up with answers that are not going to make any practical difference, because the court is going to be acutely aware that states have spent 30 years negotiating this matter, and they are not going to step in and suddenly legislate. So the overwhelming likelihood is that if you ask a general question, you're going to get a very general answer, which isn't going to help, for example, national courts take the matter forward at the domestic level, or other regional bodies take the thing that forward. So the crucial question has to be, what exactly are those questions that can be asked? And my concern, I'm very supportive, obviously, instinctively, of the effort recently announced by Vanuatu. But what is the question Vanuatu wants to ask the court? We don't know. There's no indication. And the problem with doing it in this particular way is that if you don't start with the questions first and work out questions that are capable of producing answers that can have a practical consequence, for example, on the state of the science and the extent to which certain arguments can and cannot be made today in relation to the state of the science, questions that are partly factual and partly legal, which require the court to form a clear view on the state of scientific knowledge, scientific information, and the consequences of that in terms of law that must follow. I fear you're going to get decisions that are, like the nuclear weapons advisory opinion, either useless or worse, damaging. So those who are involved in this effort have got to constantly ask themselves the question, who is on the court? And what are the judges going to do faced with a question? The judges will not legislate on climate change. One of the experiences that we went through in drafting our definition of ecocide, just to give you a similar story, we were 12 on the group. It was a wonderful group and a very consensual group, and I was very pleased that we ended up with a consensus. But there was a really good debate. Should we include particular examples of what might be the crime of ecocide, or acts that could give rise to the crime of ecocide? And some in the group said absolutely, and if you are going to list certain things, of course you've got to list climate change, they said. Others in the group, and I was part of that alternative view, would absolutely not. We cannot mention climate change in relation to the definition of the crime in relation to ecocide, because the moment you mention climate change in it, the project is dead. Why is it dead? It's dead because states are not going to adopt at the International Criminal Court a definition which at a stroke could have dramatic consequences for climate change when they are simultaneously negotiating with such difficulty. And so we came up with a definition that of course doesn't mention climate change or indeed any other forms of environmentally harmful acts, precisely to avoid creating a coalition that will be against getting it on the list of treaties that are adopted. And I think one has to be very, very strategic about this. An advisory opinion from the International Court of Justice is not the end that is sought. The end that is sought is an advisory opinion that can actually make a difference. An advisory opinion that can set out with absolute clarity a finding of fact and an interpretation of law that can then be picked up by others, in particular national courts or national governments or regional governments or city governments, so that it can no longer be said, you can't do this, you can't do this, because the court has already set out a clear view. My own sense too is that one should look very carefully at the International Tribunal for the Law of the Sea. It has a very decent group of judges also. It is underutilized. And the impact of climate change on marine resources, whether it be sea level rise or coral reefs or fish or flora, fauna of the oceans or whatever it is now coming to be known. And I'm wondering whether there isn't a more appropriate forum at the International Tribunal for the Law of the Sea. Many people will say very reasonably, but ITLOS doesn't attract the same attention and so on and so forth. And I think that is right. But I think that body may be more likely to come up with something, given its track record on these matters, that is specific and that is usable in other fora than in the International Court of Justice. So I don't exclude at all. In fact, I would strongly support an effort to go to the International Court of Justice and or also the International Tribunal for the Law of the Sea. And they're not mutually inconsistent. You could do both, but you've got to spend a lot of time working out the question, because if you get the question wrong, the effort will be, I fear, absolutely futile. Lavagna rightly made the point that one of the things the International Court of Justice can do, or ITLOS perhaps could do, is to interpret text where there is ambiguity and bring clarity. But international judges, particularly those on those two courts, will be very alert to the accusation that they are legislating, which of course international courts cannot do, rather than interpreting and applying. And that is a very fine line between interpreting and applying the law on the one hand and legislating on the other. So this is a sort of reality check. I hope I'm not being heard as being a naysayer and opposed, but since I spend time in these institutions, I urge everyone, before they run too fast and too hard, to ask themselves the hard question: what actually do they want out of it that could be useful in a hard and practical sense?
Thanks, Philippe, for these very good insights into the practicalities also of going to court. Yes, I do agree that the International Court of Justice and ITLOS will not don't want to be seen to be legislating. We are going to have a discussion on this in a short while. Before we do it, there have been some questions to all three of you, which we will try to answer. But before, I would like to give us a little break, because this was quite a lot of food for thought, of 2 or 3 minutes. And during this time, we will conduct an opinion poll. We've prepared some questions to you, because we would like to know, and also probably you would like to know, about who is listening here. So we're going to be asking whether you're a lawyer or non-lawyer, and whether you're from Germany or not. Please, to our technical support, can you show us the opinion poll now? And I'll be back in 2 or 3 minutes. Thank you. Okay, question to our support. Do we have enough votes now?
We do.
Can you then please show the results? Okay, thank you. So we have got actually a majority of our audience coming from outside of Germany. I'm very happy to have this reach. In terms of professional, non-professional, the majority, two-thirds, more than two-thirds actually, lawyers, either law students, a smaller faction, or practicing law. And third question, there was something that I would like to discuss also with my fellow panelists here, whether one of the reasons why we don't see international environment or climate litigation may actually be due to the fact that the procedural ways, the structures, the infrastructure is actually not there. And that's why I was asking the audience whether they thought that we needed an international court on the environment, and well, 79% said yes. Thanks for this opinion. We will save that and make it available. Can I now ask fellow panelists to come on stage again? Thank you, all three, I would like to say. I mean, Philippe, taking this last question of you up, first of all, very good, and we could also see that in the chat from the comments, very good to kind of warn against against hastening and being aware of the complexities and very, very precise in the questions. If you think, of course, the court will avoid to be seen to legislate, but most people who are thinking about that are actually talking about the consequences. Of course, the court would not say it's illegal to emit greenhouse gases into the atmosphere and it has to stop in 5 years. But the consequences of findings, which might extend, for example, to the question of what about climate refugees? Wouldn't they deserve a special status under international law, considering the fact that every state and every inhabitant in every state is in some way contributing to the problem? I was referring to deterritorialization. I mean, that the fact that the territory of the state is disappearing, doesn't that call for some rule that other states may have to provide a substitute territory for that state? Questions which go to the foundations of international law, really. Do you think that it might make sense to ask these kinds of questions to either the ICJ or to ITLOS?
I mean, I'm reading the chats also, and my position hasn't changed since I gave a lecture in the Supreme Court of the United Kingdom 5 or 6 years ago, where I announced or made clear that I'd shifted from being completely skeptical and opposed to the idea to being very open to it, provided you get the question right. The challenge is that in the last 5 years, I haven't seen in black and white on a piece of paper the 2 or 3 questions that will make me think, yes, actually, that is really useful. Now, you are identifying precisely one of the areas that I think would be extremely useful, because there are going to be questions about the status of the 1951 Convention and the extent to which it does or does not apply in circumstances caused by massive environmental change. Sea level rise is going to make some territory disappear, and there are going to be profound legal questions about the extent to which an island state, for example, can claim areas as part of its exclusive economic zone and continental shelf where those islands have disappeared, as in the film that Sophie showed us. If your island's disappeared, does that mean you no longer have a base point on which you can delimit your maritime boundary? That is a hard, practical legal question. The problem with that question is it's premised on climate change happening. And I think most people who want to go to the International Court of Justice or ITLOS, what they actually want is to contribute to a change in consciousness. And that's a really useful exercise. I think that was the hope with the nuclear weapons on advisory opinion. So you don't want to ask a series of questions that don't go to that core question. Now, theoretically, I suppose you could imagine that the court would come back and say that the burdens are so onerous on a state if climate change happens and refugees arise in vast numbers, which it seems that they will, that somehow this would encourage states to stop it from happening or take more steps. And I suppose that is an argument, but it's less direct, shall we say. And that's why I can understand people have not focused on those kinds of issues. But there is here a real hard challenge. And what essentially you need is a pretty small group of people who are going to sit down and work out, having regard to the need to change consciousness, but also come up with an advisory opinion, whether it's ICJ or ITLOS, that's actually going to make a difference and isn't going to be so crushingly general or doesn't deal with a situation that climate change has already wrought its horrors so that it's just there to clean up the mess. There is the question of liability. You know, great, we can ask questions on liability for climate change and consequences of refugees and islands disappearing. Frankly, that's not going to be very helpful in getting states to increase their emissions cut at faster rates and so on and so forth. So it is very tricky and very challenging. But the difficulty with what's happening now is that it seems that it's being done, apologies for the expression, sort of arse over elbow. People want an advisory opinion from the International Court of Justice or ITLOS, but they don't actually really know what they'd ideally like the court to say, or they don't really know what the court could usefully do. And I think that's the first thing to do. Work out with absolute laser precision, as we did in the Chagos advisory opinion. If we got a piece of paper that said this, can we use it politically? Can we use it legally? Can we use it socially? And we got that. And it's been very helpful. And it's led already to changes. Just last month, the Universal Postal Union has banned the use of British stamps on the Chagos Archipelago. And the British are really upset about it. And you want to do the same thing. Start by asking yourself the question, what is the line in the advisory opinion that would make a difference? And then work out how you get that line, whether it's in relation to sea level rise or emissions or coral bleaching or refugees or whatever it is. I think it's possible to do it, but it is a tough call. But I think that's the way to do it, rather than we want an ICJ advisory opinion, but actually we're pretty clueless on what exactly we want them to do. Work backwards and ask yourself the question, what is the sentence in the advisory opinion that would thrill you? And how do you get it? What's the sentence in the advisory opinion that would depress you? And how do you avoid getting that?
That's a very good advice, anyway, for each undertaking. Before we go to some questions from the audience, I would like to invite our two co-panelists, Sophia and Lavanya. Is there anything in the talk of Philippe or one of yours which you would like to comment? Not, I mean, too broad, but I would like to give you a very quick option to comment and maybe answer a question on your own. Lavanya, do you want to start?
Thank you, Herman, and thank you, Philippe, as always, for your sort of laser precision on the problem and the sort of solution we need for it. I completely agree with you that the question needs to be very carefully drafted to get the right kind of response. And I also agree with your instinct that we need to ask questions that address the problem today, that make up for the deficiencies we have in our ability to address climate change in the way we need to do it within the narrow time frame that we have to address it decisively today, rather than focus on cleaning up the mess, as it were, once climate change has wrought its horrors, as you so eloquently put it. But to do that, I think we need to focus on how we interpret the obligations. And it's true, there's a very sort of blurred line between legislating and interpreting and applying the law. But I think the one thing we do not do in very well as lawyers is to look at the Paris Agreement and say, well, this is not the end of the story. This is not just a politically wrought legal document. It is set within the context of customary international law. And to interpret the obligations within the Paris Agreement, we need to read those obligations in the light of customary international law. And I think the extent of privileging we allow for national determination because of the political processes that led to the compromises in the Paris Agreement is at the heart of the problem. National determination cannot run riot, and it's national determination running riot that is leading to the sort of ambition gap, in a sense, in what we need to do today to address the problem. And we need to recognize that ambition gap is because we're not reading those obligations in the light of other obligations that states have. It is not just the ambiguous phrasing in the Paris Agreement. It needs to be read in the context of customary international law obligations. And I think that, in my view, is what the International Court of Justice can do. And of course, the question will have to be very precisely formulated to get the kind of answer that we want. But we need a very precise standard of due diligence attached to what states are doing to their obligations of conduct. So that standard of due diligence can, for instance, be drawn from the science, from the fact that the latest IPCC report tells us it's unequivocal that human beings are contributing to climate change and that the results are going to be devastating. And drawing on that science, what is the standard of due diligence required of states in the context of that science? So the facts are clear. We don't need to dispute the facts. We don't need the ICJ to pronounce on the science. The science is clear, it's unequivocal. What we need the ICJ to say is what we require of states in the light of that science, which is unequivocal, and that the Paris Agreement and the provisions of Paris Agreement are not to be read in isolation. I think that's what I think the ICJ very usefully do in this context.
Okay.
Thank you.
Thank you. Sophie?
Thank you. And thank you, Philippe, for your comments, and also Lavanya for your views. I do tend to agree with Philippe that a generally posed question to ICJ and a very general level pronouncement does run the risk of not potentially moving the dial. And I also agree with Lavanya that the real answer that we need from international courts and tribunals or treaty body mechanisms and compliance mechanisms is the practical question, as Lavanya said. So what does a state need to put in its NDC? What does highest possible ambition mean? How does the state demonstrate that it is pursuing highest possible ambition? And there's a series of potential criteria that one can use to assess highest possible ambition. My colleague Sam Hunter-Jones and I wrote about that and proposed a set of criteria around process-driven criteria around transparency. Has the state, in setting its emissions reduction target, has it modelled a range of different outcomes? Has it selected a target at the top of the range, etc.? So there are a number of questions that can be worked through. And that's really, I think, putting the meat on the bones of the NDC obligation in the Paris Agreement. So, and therefore, I think strategically it would be fantastic if there could be a case or a proceeding about the meaning of highest possible ambition. So that could be potentially through the Paris Agreement Compliance Committee. I think we're really interested to see how effective the committee can be in assessing compliance with the Paris Agreement and helping to provide more detail on what states need to do to fill that ambition gap and practically have an example of a state that is failing to meet its obligation, its highest possible ambition obligation. I think that would be really helpful. And then generally, overall, I've always thought that a contested case where we had a concrete example with a court that would examine to some degree the policy of a specific state would be potentially more useful than an advisory opinion, and that could be possibly at the ICJ or ITLOS under the relevant provisions there. Of course, that brings a whole series of other challenges around interstate disputes and obviously the politics and the circumstances and facts of that dispute would need to line up, and states would need to be willing to step out of perhaps their political comfort zone to do that. So we shall see whether such a case arises in the future.
Thank you. There's one question in the Q&A tool which refers to this question of who is going to litigate. Do you think there has not been enough focus on global South climate litigation? What are your thoughts on the influence of the dominant global North literature on the matter? Would you agree that judges in the global South tend to be bolder in some instances when ruling on climate or climate-related cases? Who would like to step in here? Lavanya.
I'm happy to say a few words on this. I think there has been perhaps a lot more focus on the climate litigation in the global North, but there are cases in the global South. The Ashgar Legari case in Pakistan was sort of the first of the cases, but there's a case Shwerste from Nepal, and there have been several cases in the global South that are sort of picking up, especially in the context of human rights implications of climate change. So to the extent that many constitutions, especially in South Asia, have very expansive rights jurisprudence and expansive public interest jurisdiction that the courts sort of exercise. There's tremendous potential for cases, and there are cases coming in through the pipeline on climate change and impacts. I think the more interesting question in a lot of the global South litigation might be cases relating to adaptation and human rights rather than just mitigation, which of course then raises issues of fair share and global burden sharing. The more interesting issues which all states, but particularly developing states with limited resources, have to address is how they protect their citizens and the progressive realization of rights for their citizens from the impacts of climate change. So there is interesting case law that's developing and is coming to the fore, and there are already sort of quite influential cases that are there from the global South. But of course, the literature focuses perhaps more on the global North, but there are cases coming up. Thank you.
Thank you. Philippe, there's a lot of questions regarding to the question. So what is the real question? There's also a hint to a recent article by Michael Gerard, including, as it is written here, 2 proposals for the question. Are you aware of this?
I've got them on my screen, actually. I've been following the chat. And just so that everyone knows what one of the questions is, what are the obligations of states under international law to protect the rights of present and future generations against the adverse effects of climate change? So with respect, that is exactly the kind of question that has to be avoided. I mean, if you ask judges a stupid question, you're going to get a stupid answer. It's so general that you're going to have 15 judges on the court, and they could just say, the obligations are set forth in the UN Framework Convention on Climate Change, and that's what you've got to give effect to. You know, don't imagine that you're in the Dutch courts with a firm, grounded institution with a long history, able to consider taking on the executive. Look at who's on the International Court of Justice. More than half the judges are former legal advisors or ambassadors of governments. Okay, they are going to be acutely conscious of what the consequence of this is. So I don't think that's Michael Gerard's proposal. He's referring to the proposal of others. And I can see why from the outside of the court, that seems like it would be really useful to have an answer to that question. Go and spend some time hanging around the International Court of Justice, okay? And look at what they do. Look at what they did in the advisory opinion on Kosovo. Years spent preparing a question on whether Kosovo could or could not declare independence from Serbia. A myriad of papers presented, arguments made, countries participating, and the response is just completely impenetrable, and precisely zero has happened in legal terms since then. So that is exactly the kind of question I would want to avoid. And I think what's been helpful about this conversation with Lavanya and with Sophie is that the comments that they're making are consistent with zeroing in on something that leaves a reasonable judge with no wiggle room. Basically, you want a yes or no question. Yes or no. There's no other way. And that's what we did on Chagos. We designed the questions so that they couldn't say maybe. They had to say, yes, was decolonization completed or not? Not maybe, it's yes or it's no. And basically all the judges, no judge dissented. They all said, no, it hasn't been completed. The one judge dissented, did so on jurisdictional grounds. There was no dissent. So it's got to be a question where you could imagine judges from China, from Russia, from the global south, from Germany, all reaching the same conclusion. Because if, for example, the science is, as Lavanya says, as clear as she says it is, it ought to be possible to frame a question which allows the application of that clarity to a legal issue which would actually make a practical difference. And that's beginning to get to the point. But put yourself in the position of the judges. They cannot be given any wiggle room, and they've got to try to be encouraged to find a consensus. You don't want a 7-7 decision. Catastrophic.
Thanks, Philippe. There's a question on ITLAS, on the International Tribunal on the Law of the Sea, or there are some questions, and but basically audience is asking itself, so what is the legal basis if you want to go to that tribunal? Because that's not the primary goal and objective, of course, of the Law of the Sea Convention. And I would like to, because I also know that Sophie has done some research on that, maybe start with you.
Sure. So I think that the UNCLOS is an incredibly fruitful and fertile area of potential assistance in the climate change question, and that because the UNCLOS, I think it's Article 194, there is a general duty on all states to prevent pollution of the marine environment, and that definition includes pollution from sources on land. As we know, greenhouse gases, territorial greenhouse gases emitted on land, absorbed by the seas, causing heat to be retained by the seas and consequent impacts on biodiversity and the marine environment. We have done an analysis and had legal advice that climate change could be included, and that greenhouse gas pollution could be arguably included in that definition under Article 194 in the Law of the Sea. That potentially provides an avenue for a contentious state-to-state dispute with us under UNCLOS in the International Tribunal for the Law of the Sea, with one state arguing that another state's emissions reduction policy under the Paris Agreement is insufficient to meet that duty, that they're not meeting that positive duty. So that article gives you a hook. And it is, of course, would still be a really challenging claim. There are a number of elements to be made out there, but because there's that general duty on all states to reduce pollution of the marine environment, that we think that gives the hook. So that's it in a nutshell.
Yes, thanks. So, Philippe, anything you would like to add?
No, I think so. I think that's the fertile ground to look at. I mean, there are some really interesting questions. Some of the people on the audience will know that one of the issues touched on by Lavanya, joint and several liability, is a real issue. I mean, famously in the Nauru case at the International Court of Justice, there was the question of whether Australia and New Zealand and the United Kingdom, possibly a couple of other countries also, could be sued individually in relation to obligations owed to Nauru. And you've got a similar issue in relation to some of the points just made by Sophie. can one state bring a case against another state in relation to a situation where the respondent state is only one of many that is contributing to the problem? That's a really important issue. Now, if you could get an answer which says actually, yes, you can, that would be actually pretty useful, because that would actually open the door consequentially to further proceedings. So you could imagine an advisory opinion which gives, asks us to give a yes or no answer as to whether the state of current international law under the Law of the Sea Convention, one state is entitled to bring proceedings against another state in circumstances in which the pollution of a maritime space, which could include warming, has occurred. And that's what I'm thinking. I mean, the folks who did Agenda and these other cases have been thinking brilliantly, strategically, and they've created a sort of cascade of decisions. And you can see when you talk to national judges, they're looking over their shoulders. They don't want to be the country that's left behind. The plonkers who've said, no, you can't do this, when 17 other countries have done it. And what we want to do is, if we're going to go to the international level, we want the judges at the international courts to feel that also, look, this is what the national judges are doing. We want to be part of this process for future generations, but we have to help them do that. But I think this is a helpful conversation because it's beginning to home in on the practicalities.
I think that's one of the most fascinating aspects, how much actually courts from very different jurisdictions observe each other's rulings and quote them. Also, the Constitutional Court in Germany quoted some others. The same, I think, will be true for the international tribunals and courts. I mean, we, Client Earth in Germany, would have a special interest, of course, in turning towards the International Tribunal on the Law of the Sea, because of the seat, basically, which is in Hamburg. One question that you...
Just on that point, what you want, what you want is you want a case at ITLOS in Hamburg, and you want thousands of people out on the streets, because nothing concentrates the judges' minds more when there's significant public interest. If you have an advisory opinion and you've got two people and one banner at ITLOS, they're going to say, well, actually, no one really cares about this. But when you've got people, when they drive into the court and there's a crowd of people, as happened on the Rohingya case with Myanmar and the Gambia, and also to a certain extent, Chagos, there was quite a lot of interest there. People, that does concentrate the minds of the judges.
That's a very practical advice. Thank you. Moving on to some questions. Lavanya, I didn't address this question to you, but if you have, no. There's one question on the international investment arbitration. Quite rightly, Philippe, you pointed to the fact that this is usually a bit neglected. And the question is, what kind of procedural changes to the practice of arbitration would you consider useful and feasible to ensure that investment arbitration does not undermine climate action? I'm thinking particularly of emerging cases challenging fossil fuel phase-out measures.
Who is that question to?
To you. Mm-hmm.
Oh, okay. Sorry, my phone rang at that very moment. I got momentarily distracted. Could you just put the second part of your question again?
Yes, it concerns the procedural changes that might be necessary in order to ensure that investment arbitration does not undermine climate action, and we're seeing that in certain...
I have to be very, very careful what I say, because I'm sitting as an arbitrator in numerous cases, and I cannot be seen in any way to be encouraging litigation or particular types of arguments. I'm speaking here in my academic capacity. But you can imagine, let me give an example. There's a very, very interesting case. Al Jazeera brought a case against Egypt to promote, where two of its journalists were arrested in Egypt. and they brought basically an investor-state arbitration case to promote freedom of expression. And that sort of tweaked in my mind the idea, you could sort of imagine a rather progressive, I'm saying this entirely hypothetically, firm that has made an investment in a jurisdiction, and the state concerned has failed to take measures in relation to the protection of the global climate, and in that way is effectively underwriting or providing support to a more sort of, we say, conservative competitor corporation, which benefits because it doesn't have to ramp up its technology or do various other things. So I think there's scope there for really creative lawyering on turning it around. The system doesn't need to be tweaked. The procedures are all there, fair and equitable treatment. Turn it around and use it in another way to clobber the state that is not meeting its international commitments on climate change. I can see that kind of argument being made. Now, whether it's successful or not is another matter. That will depend on who the arbitrators are. But I think there's quite a lot to be done there.
Thank you. Lavanya, you don't have the constraints of being involved, I hope. And you may have a second opinion on that. And also, you've said before that you would have to leave a couple of minutes earlier. So maybe you could use this also for some last words to our audience.
Thank you, Herman, and thank you both to Sophie and Philippe again for great sort of interventions here, and also to the audience for some really fascinating questions. I don't have much to add on investor arbitration, state arbitrations, except to say that the nature of the Paris Agreement and the architecture of the Paris Agreement do make it slightly more challenging to I guess, challenge states to say that they're not complying with their commitments, because these commitments to some extent are self-selected, and they have a range of commitments that they can choose to meet their goals. So the Paris Agreement is not prescribing certain types of actions from states, and states are choosing them for themselves. So it's a little bit more challenging in that context. The nature of the architecture makes it a bit more challenging, I think. But having said that, I think I did want to pick up on creative lawyering that Philippe mentioned, and on one question that you haven't raised from the questions, but I thought it was quite interesting from the Q&A, is about the goals in the Paris Agreement, and what if those goals are not sufficient? What if the science sort of demonstrates, as is actually increasingly becoming the case, and we have the sixth assessment report sort of Working Group 1 report has come out, Working Group 2 and 3 will come out in the course of the next year. What if the science actually demonstrates that the Paris Agreement goals are not enough, and all the litigation is based on the Paris Agreement goals? And I think that's where some element of creative lawyering is useful. And creative lawyering, not just in the context of litigation, but creative lawyering also in the context of the development of the regime under the Framework Convention and the Paris Agreement. For instance, the global stocktake that is to take place in 2023, it is meant to take place under Article 14 of the Paris Agreement. The global stocktake is meant to take place in the light of science and the latest science. The latest science is telling us that the goalposts have shifted, and that's something we need to be responding to. And the regime needs to be dynamic enough to respond to that. So the kind of information that goes into that stock-taking process, the moment of reckoning, for instance, should take into account the shifting goalposts based on science. Similarly, I think in litigation as well, lawyers should be creative about those shifting goalposts based on science. There were a couple of other questions in the Q&A as well about attribution science. And again, that's also, I think, the science on that is developing rapidly. And it is becoming possible now for science to tell us that certain extreme events, the chances or likelihood of those extreme events occurring due to climate change has been sort of exponentially increased because of human interference, and that does strengthen cases. So I think the use of science the use of latest science and creative lawyering to integrate changing goalposts and sort of introduce some sort of dynamism into not just the international climate change regime, but also into national sort of policy making and litigation is much needed right now, given the situation that we're in environmentally. Thank you.
Thanks, Lavanya. It was really a pleasure to have you here with us. And for the last round, I'm turning to Sophie.
I think I'd just like to thank my fellow panelists for their fantastic contributions. And I really do think that Philippe's comments have certainly made me reflect on the strategic opportunities. I think, particularly in international law, we can't ever forget the politics and the interaction of international litigation with the negotiations at the UNFCCC level. And I think that, the progress and the route that the UNFCCC and the Paris Agreement takes may in fact determine whether or not we see contentious or other alternative dispute resolution mechanisms attempted at the international level. If the Paris Agreement works, we may not see these kind of interstate cases. However, if certain particular small and more climate vulnerable states don't feel that they are getting the outcomes from the international process, perhaps then they'll turn to more contentious proceedings.
Thanks. I think low-lying island states are actually showing an exceptional amount of patience in these climate negotiations, and certainly, Glasgow COP27 in November will be the litmus test whether the large emitters actually deliver on their promises or not. But as in the national jurisdictions, it may be high time for international litigation to take place. And Philippe, I don't know, are you still there? Then I would like to hand over to you for some last words.
I'm just about to rush off. I'm just I've got to go to give a talk in Innsbruck.
Thanks a lot. and we stay in contact bilaterally. These are extremely important questions and very
it needs to happen. This needs to happen because it's a way of galvanizing attention, support, and energy, but it's got to be done in the right way. It must happen, but it must be done properly.
So let's sit together and think about the right way. Thanks, Philippe, also, and good luck for your talk.
Thank you.
And also thanks, Sophie, and everybody who's been listening. It's been a really, really interesting chat and quite successful. Our first English speaking online seminar. This is the 6th in our series, the 3rd this year, and I hope that we will have a good message soon, that we will also that we can also plan for 3 more online seminars in the coming year. This is meant to support scholars, students of the law in the attempt to make public interest litigation, strategic litigation in the environment field more known, better known, and more widely used, because that's usually not being taught at the universities. And so thanks everyone for this memorable event, and hope to see you, well, soon in another context, but definitely next year again with a new series of seminars on public interest litigation in the realm of the environment. Thanks and bye-bye.